I'm going to rant about something we've talked about before, but I want to revisit because I believe it's very important in terms of a risk management tool, and that is the Code of Ethics. There are a number of the codes that have some specific applications to not just what's going on today in the market under normal circumstances, but also what's going on in the market because of COVID and because of some other issues. So again, we're not going to talk about what's happening at the federal level. As I'm recording this, we have a new president, and he's doing some things that are going to affect real estate. Probably going to expand the moratorium on rental evictions. Obviously, the state is very active. The legislature is open for business, and we're seeing the results of that. There probably, as I speak today, next week, there will probably be an extension of Assembly Bill 3088, which prevents landlords from evicting based on non-payment of rent. And of course, we have all kinds of local things going on. So realtors are kind of in this flux because you've got all these duties. The duties are changing periodically, but all this responsibility. So what do you do? So first of all, I want to remind everybody that this isn't just about the association and its code of ethics. This is about the fact that in California, the National Association of Realtors Code of Ethics is the basis for all of California real estate law. In fact, at one point, there actually was a statute that said that. That statute is no longer on the books, but pretty much if you look at California real estate law and you look at the Code of Ethics, you're going to see real similarities. And on a couple of these today, I'll touch on it. Also, it does affect your liability. I hear the word liability all the time. All lawyers do. And liability means that you have violated your duty or your legal obligation, if you prefer. And of course, today, your duties have changed. Last February, you didn't have a duty to have the house properly cleaned and ready for the next potential buyer. You didn't have duties to sign declarations and have declarations signed indicating that no one had a virus or things of that nature. There were things that were not imposed on you. You had duties to do reasonably competent visual inspections, which you still do. You had duties to disclose material facts, and in cases where you were representing a client, material information, you still do. But what that information might be and what those facts might be has been altered and expanded. I don't know of anything that you don't have to do anymore, but there's a whole bunch of extra stuff you do have to do. Then the other question is, what is the standard of care for a realtor? The standard is measured by what a reasonable realtor would do in any given situation. So how do you measure that? Well, when I was in law school, I asked my professor, what does the reasonable person look like? How do we measure that? And his comment, and he was a justice on the Court of Appeals at the time, his comment was very simple. A reasonable man is whatever the jury or the trier of fact thinks it is. So in the context of civil litigation, the reasonable person and what you should do is ultimately going to be judged not only by what experts say you should do, but then at the end of the day, if there's a conflict, the jury gets to decide those factual issues. And so it's very complicated sometimes. And then of course, there's the duty that you have, and then falling below the standard of care, which lawyers commonly refer to as the breach of that duty. And then thirdly, in order to be able to establish that someone is liable, you have to be able to establish that the duty that was breached was a primary cause of whatever damages were sustained. That's going to be a really interesting issue on a go-forward basis, because how are you going to prove that you got sick at a house, or how are you going to prove that conduct led to someone being ill? And of course, we're going to probably see some legislation and some cases on that. And then lastly, of course, there has to be damages. And damages can run, in this context, anywhere from someone dying as a result of somebody not doing what they were supposed to do, to property being reduced in value, to no damages at all, because the fact that someone was sick in a house led to nothing, and therefore no damages. So again, you can see that there's a lot going on here in that respect. And then, of course, if there are damages, in a civil context, those damages could be an amount of money that the jury would award to the complainant or the plaintiff for whatever the jury felt was appropriate, so long as it, passed muster by the judge. If it's a DRE issue, then the damages could be the loss, suspension, or limitation of your rights as a real estate professional, because the DRE imposes a sanction in the form of a suspension or a limited license, or maybe a citation with a monetary penalty. And so the DRE has a say in how you're to be damaged. And then lastly, of course, the association can fine you up to $15,000 for a violation of the code of ethics. And that depends on a whole lot of factors as well. So as you can see, a lot going on here in terms of your liability, in terms of damages, and in terms of different kinds of issues. So what I decided to do today, and shouldn't take long, is I just want to go through the code of ethics. And I picked out, and this is by no means a complete dissertation of everything that conceivably could be the case. I would strongly recommend that you go to the association's website and that you take a look at the code of ethics and read them word for word. There is nothing wrong with doing that. It is something you should do on an annual basis. The current code of ethics is dated January 1st, 2021. They made one significant change, which I'll mention in a minute, and read them. Read not only the articles, but read the standards of practice. And that's what I'm going to zero in on today, are the standards of practice. So Article 1. Article 1 is commonly referred to as the breach of fiduciary duty article. Article 1 basically indicates that when representing a buyer, seller, landlord, or tenant, that you put that client or that customer's interest primary. And again, I'm not going to go into what a client is or what a customer is. Obviously, if you have a written agency agreement or have made an offer on behalf of a potential buyer or have negotiated a lease, those are clients. But then you also have customers, people that you service. And so you have a duty to put their interests primary or first. You also have a duty under Article 1 to be honest with everyone involved with the transaction. And honesty means that you indicate what the facts are, what the truth is, what information is required to be submitted, and that you tell a full, complete story. And again, that's measured by a number of factors. I want to zero in, though, on a couple of articles. First of all, Article 1-2 indicates that the duties that are imposed by the Code of Ethics encompass all of your real estate related activities. So whether you're representing yourself, a client, working for free, if you're in a situation where you're working on a real estate related activity, you have a duty to comply with Article 1. And then we have 1-9, and I'm simply going to read it to you. Well, I'm not. I'm going to read a portion of it. That you have an obligation to preserve confidential information. It lists what the confidential information is, under what circumstances you should disclose information that might otherwise be confidential, how you get your clients to consent or not consent. So confidential information today is very important. And sometimes confidential information is something that may have an impact on a transaction, particularly if somebody got sick in the house or someone who's coming out to the property is not well or has gotten some of the symptoms. And so you want to make sure that you understand your duties relative to maintaining confidential information when information is not confidential. Then we have Article 1-10, and this applies primarily to property managers, but I think you could make an argument that it applies to all realtors. It says realtors shall, consistent with the terms and conditions of both the real estate licensure and their property management agreement, competently manage the property of clients with due regard for the rights, safety, and health of tenants and others lawfully on the property. So again, we see that there is a feature in the Code of Ethics specifically as to rental property tenants of making sure that you don't do anything that's going to affect their health or safety. And I know today one of the hot button topics is going to be a tenant who says, you know what? I don't want people in my property. Or if people are going to come into my property, I want you who may be showing my property. Maybe the seller's decided to sell, and the tenant is cooperating in that regard. You still have a duty to that tenant to make sure that people that have symptoms or people that have conditions are not coming onto the property without verifying that they're not sick and that they don't have those symptoms. That would apply not just to potential buyers, but repair people who are required also to sign the PEADV form. And it could be a repairman, it could be an inspector. Anyone going into a rented property needs to be very clear that that they're in good shape, and you need to make sure that happens. Now, Article 111, realtors who are employed to maintain or manage a client's property shall exercise due diligence to make reasonable efforts to protect it against reasonably foreseeable contingencies and losses. So again, you can see where contingency is a condition that could occur before something else occurs, and you want to make sure that these contingencies are consistent with the other duties that you have to protect the property from harm. Then we have Article 1-11. Well, that is 1-11. 1-12 talks about entering a property and making sure everyone understands what the policies and procedures are. And then there's 116, and this is an important one. It says that a realtor shall not access or use or permit or enable others to access or use listed or managed property on terms and conditions other than those authorized by the seller. So again, very, very important that you have these conversations with sellers. What are the lawful, legitimate things that a seller can require? A seller can say, I don't want anybody in the property that hasn't been vetted for the illness. So I want a PEAD form. I want to make sure that no one comes who is not properly vetted in terms of their qualifications. Obviously, we don't do open houses right now, but in any showing to a prospective purchaser, all of the things that need to be done have been done. And I am telling you that, and you need to make sure that the buyer's agents understand that. Also, of course, there could be other issues. For example, a seller may say, I want limited access to the property. Nobody comes unless they've signed the form. They are pre-qualified. In some cases, I've seen people say, or I also want to confirm that they have verification of funds done before anything goes forward. So again, as long as it's not unlawful, we're going to talk a little bit in a few minutes about discrimination. What I can say is I want those things that I just mentioned, and I also don't want you to show the property to anybody who's in one of the protected categories of race or ethnicity or sexual orientation or one of those things. That is invalid. So you have to be able to differentiate between what is lawful and what is not lawful. All right, moving on. Article 2. A big article all the time. Article 2 basically indicates that a realtor shall not and shall avoid all exaggeration. And of course, the difference between a sales pitch and exaggeration sometimes is a fine line, but you're also to avoid all misrepresentation, which is another word for a lie. And there's two kinds of misrepresentation. One is misrepresentation because of an outright lie. I know I'm not telling you the truth, but I'm going to tell you anyway. And I'm lying to you, and I'm hoping you'll change your position and I'll get what I want. Another form of misrepresentation is called negligent misrepresentation. And that is where somebody says something without any real basis for knowing whether it's true or not. You know, this property is 2 acres and nobody's done a survey and nobody really has measured it, or whatever it might be. There's criteria for that. And then the last thing, you will not conceal pertinent facts. Pertinent facts are facts that are in your realm of knowledge, either because of an inspection you did or knowledge that you have because you're familiar with the property or the area or the location or something like that. You will not conceal material facts from a buyer. You will not conceal material facts of any kind from a seller. You will disclose all material facts, and you will disclose, if it's to a client, all material information. So those things are very, very important. Article 3, this one comes up all the time. I know Lori Smith, who does professional standards management for the association, cognizant of the fact that agents sometimes just don't cooperate with each other. Remember, if I'm hiring a realtor to be my listing brokerage, I'm hiring them because they've told me they're going to actively market the property. They're going to put it in the MLS. They're going to do whatever they can to get not only themselves and their office, but all other real estate professionals to market my property so I can get the highest, best price under the best terms in a timely fashion. So when you fail to cooperate by not providing information, by not making the property available, then that is a breach of your ethical duties under Article 3. And it is a duty that you owe to the client, not a duty you owe to other realtors. So there's a couple of passages in Article 3 that, obviously you can negotiate compensation so long as you don't put it in the offer itself. It says no, that standard practice 3-2, which talks about limiting the way you deal with compensation, that the listing broker and cooperating broker can enter into another agreement to change cooperating compensation. So you can do that, just can't do it inside the body of the contract. 3.9 is very, very critical. Remember, I told you just a minute ago about 1-16, which is how the listing office finds out from the seller how to grant access. Well, 3-9 is a duty that is owed by cooperating offices, and it says realtors shall not provide access to listed property on terms other than those established by the owner or the listing broker. So if the seller and the listing broker have set up a criteria regarding access to the property, regarding wearing masks, whatever it is, which is also part of the duties under the law, then it is an unethical act to violate those reasonable standards, which probably are in the MLS comments and so forth. So again, it's an ethical duty to comply with the code of ethics cooperation as it relates to whatever the seller has legitimately said cannot be done. I also want to point out something new that has to do with a very, very big issue right now. In addition to the pandemic and all of those related issues, we have a very front burner issue, which is fair housing and discrimination. And in January of last year, 2020, NAR added a standard of practice 3-11, which says that it is a violation of Article 3, which is the duty you have to your client to not cooperate with another agent simply because of the color of their skin or because of a disability. And I'm going to read you in a second all the different categories. But again, if I'm saying I'm not going to deal with Agent Smith because I just can't talk to people that are gay, or I can't deal with his disability, or I can't stand people of that race or that creed or whatever it might be, that is a clear violation not only of the code of ethics and duties you have to cooperate. It is also probably a breach of your obligations to your client because you're preventing that agent for no other reason than one of the characteristics of the category they're in from presenting the property to other potential buyers. And so you need to be careful. Now, a topic came up the other day that I thought was interesting. What if I know that Bob Smith is absolutely incompetent, that he's a liar, that he has no integrity, and he happens to be a member of one of the protected categories? He's Hispanic, or he's gay, or something like that. But I'm not refusing to cooperate because of the color of his skin or the characteristic of the protected category. I'm refusing to cooperate because it's not in my client's best interest. It's going to be a difficult burden for you to prove, but that probably is not a violation of Article 3. So moving on, I'm going to jump down to Article 9. Article 9 is a duty that you have to put all agreements in writing. And it comes up all the time. Maybe you've consented, the parties have consented to extend escrow because the bank can't get the loan docs done in time because they're short-staffed because of COVID. We actually had a case like that. Or whatever the situation is that comes up in your world, you have a duty to properly place all of that in writing and using the right form. And I highly suggest wherever possible, you stick to the CAR forms. So let me read you a couple of the standards here. For the protection of all parties, realtors shall use reasonable care to ensure that documents pertaining to the purchase, sale, or lease of real estate are kept current through the use of written extensions and amendments. So again, if you're going to extend escrow, if you're going to extend the contingency period of time, if the agreement's been reached, you are technically modifying the contract that you've already entered into. You have a duty under the code to amend the documents via the appropriate form, an extension of time addendum, or whatever form is appropriate. So very, very important. And then something that comes up a lot, particularly with DocuSign, where you're sending out documents for the sellers or the buyers to sign via DocuSign. It goes out to them. They then turn around and DocuSign it, send it back to you in the format that DocuSign allows. Article 9-2 makes it very clear that before you do all that, you must explain all of that to the client. So don't just send over a PAD form or some kind of another form, tell them to sign it. You need to go over that stuff with them. Be no different than the pre-technology stage where you actually sat down with them and went over those documents. A couple of other last minute things. Article 11, Standard of Practice 11-4 says, this is an article that says you will be competent and you will act competently as it relates to the type of property or the type of service you're providing. And Article 11, Standard Practice 11-4 says the competency required of Article 11 relates to the services contracted for between realtors and their clients or customers, and the duties expressly imposed by the Code of Ethics and the duties imposed by law or regulation. So again, there's a lot of realtors out there that don't like what the governor's done, that don't like what the CDC has done, and so they've chosen to simply violate and ignore whatever some of the rules are. And again, whether you like it or not, when you purposefully decide to ignore a rule that's been imposed and that has been then sent to all realtors as essential workers, then you are probably not competent, even if you think the rule is foolish. Article 12 simply indicates that you need to be truthful in all of your advertising. So again, whether you're advertising something on Facebook or Twitter or in the newspaper or in a brochure, you must paint a true picture of that, and that means a true picture either through your words and or through your photographs or other forms of advertising. You must be truthful in everything that you do. Then I want to jump back to something new. I know that Lori and I have talked, and we're probably going to do the next rant on this topic, and I'm doing a couple of other updates in the near future, and that's a new standard of practice 10.5. Standard practice 10.5 says that you may not utilize, and I'll read it to you, the realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, sex, religion, handicap, familial status, national origin, sexual orientation, or gender identity. It was passed on November 13th of last year. It went into effect immediately. And basically what it means is that if you engage in hateful speech based on the fact that somebody is black or somebody is gay or something along those lines, if you do that and you engage in that in any of your activities, this is not limited to real estate, but in any of your activities, you can be brought up on charges. It's about a 2-hour conversation. I don't have 2 hours right now, and you didn't sign on to listen to me for 2 hours. So we'll break that 2 hours down into a 1-hour presentation, and we'll do that during the next rant. So for now, thank you for letting me rant at you. I hope that you find this information helpful, and we'll see you the next time. Thank you very much.